Sarah Boone testified today in court, and it went worse than you could have possibly imagined. Her lawyer also seemed confused about basic facts of the case, and on top of that, tomorrow, while there's a court holiday, the judge is planning to release decisions that are possibly case-shattering. So make sure you subscribe. We're going to talk about what happened in court. I kept a lot of notes, but first, we do have to briefly mention some filings in the court. This one here is essentially the defense trying to add some case law. I'm not going to go through this. You can pause it if you need to. I am not going to go through this in this video because all of this gets argued in the actual court, and I think that kind of makes this irrelevant, but they did add some case law. I do want to read the state's response to defendant's case law submitted on September 30th, 2024, filed on September 2024, because it's very concise, and I like that. Defendant filed a motion to suppress statements on September 24th, 2024 without citing any case law to support her position. On September 26, 2024, the defendant submitted case to the court regarding her motion. On September 30th, the defendant has filed additional case law with the court. These cases appear to involve issues outside the four corners of her motion to suppress statements. The state objects to any additional claims being raised at the hearing that were not specifically pled in the defendant's motion. Vera v. State is the first of these cases. In this case, while not actively giving video surveillance of the defendant committing a crime, the police threatened to seize his truck 3 times, alleging that they did. The defendant in this case never said they had any evidence they did not have. The defendant declined viewing the videos she made. While the decedent was in the suitcase, asked to be let out. There was never any threat of the police taking any action or inaction based on what she told them. This case is inappropriate. The defendant next submitted Johnson v. State. While law enforcement specifically asked the defendant if at some point somebody gets enough, they have to do it. They have to do something to defend themselves. The defendant stated, "I would just flee. I don't know if you." There was never any suggestion, as there was in Johnson, that a self-defense claim was her only way out, much less that she would not go to jail if she claimed self-defense. In fact, the defendant repeatedly and adamantly denied there were any problems that night and denied she did it intentionally. While the defendant was questioned about how much she had to drink the night of the homicide, and that's going to be important, her drinking. Remember that. And she stated that the reason she did not remember filming the decedent asking to be let out of the suitcase was because of her drinking alcohol. There was never any suggestion by law enforcement that voluntary intoxication was a defense or things that would get better for her if she admitted that she was intoxicated. In fact, the defendant continued to insist that she was not intoxicated, despite having blacked out and not remembering filming what she said to the decedent while he begged for her to let him out of the suitcase. Therefore, these arguments, while outside the four corners of the motion to suppress, would not allow for the court to grant her motion to suppress either. So basically they're saying, look, their arguments are not actually within the motion, and even then they don't work, which is something. Let's talk about what happened at trial. And let me know in the comments as we go. If maybe you watched, maybe I missed something, maybe you don't agree with my analysis, I'm going to try to go through it. This was a lot. It was a lot, and it was very interesting. Okay, so the judge has now reviewed the entire interrogation video. So that's just, a lot of people have questioned, how has he not seen it? He's now seen it. There's no question if he's seen it, he's seen it. He should have seen it when they started bringing it up, in my opinion. Detective Kopsel was brought in to speak, detail what she remembers from the day arriving on the scene. The full discussion in the unmarked police car was recorded and turned over. Sarah was free to leave after. There was a second interview after. Her phone was extracted. This was the interview where she was asked to come to the police station. The 2-hour interview the judge reviewed. All talk on the case was recorded. So this is the detective saying everything was recorded. Now of course, there's more in there, right? But I'm giving you the basics here. This is now the cross-examination by Sarah's lawyer to the detective. They asked if the detective reviewed the interrogations. Brian Boone was not Mirandized and not considered a suspect. Sarah at some point was considered a suspect. She was asked when. The detective says the next day. Sarah Boone's lawyer asked if Sarah Boone was a suspect that day on the scene. The detective says it is hard to answer the way it is being asked because she was the only person there, and she says she was the only person there. But there were also no autopsy results at that time. The detective asked to go through Sarah Boone's phone. Sarah Boone's lawyer focuses in on was a waiver to go through the phone signed before or after they asked Sarah Boone for permission to go through the phone. The lawyer asked for a time, and I believe it was signed beforehand. The lawyer asked for the time of signing the consent form, but it isn't known, and it was before the interrogation in the unmarked vehicle. Sarah Boone gave the passcode, and the detective didn't touch the phone until after her digital team. Sarah's lawyer asked if she saw the videos on the phone. The detective says after the interrogation in the unmarked car. And that's repeatedly stated throughout this. The detective saw the videos after talking to Sarah in the car. Her lawyer confirms that order of events. At the time Sarah Boone was interrogated in the vehicle, the digital investigator hadn't even arrived. So the videos were not reviewed before the car. Sarah Boone's lawyer asks if the detective said to Sarah Boone interviewing her in the car was routine protocol. The detective says she doesn't remember exactly because it was 2020. I think that's fair. Sarah Boone's lawyer asks, would you explain to her why would you have explained to her why they were going to sit in her car? And the detective says no. Everything was explained on audio recording. Sarah Boone's lawyer is really hammering home they had a conversation before getting into the car for the recording. So basically, her lawyer at this point was really focusing on the fact the detective had to speak to Sarah Boone to get her into the car. Therefore, they spoke before getting into the car. Detective keeps saying yes about her getting into the car. Lawyer keeps specifically asking about the words routine protocol, but the detective keeps saying she doesn't remember and she wouldn't have spoken wouldn't have spoken about it before getting her in the car. I think that's what my notes here say. Sarah Boone's lawyer asked if she read Sarah Boone the Miranda card, and if she agrees she didn't read her last line. The state objects, and you're going to hear this so much. The state objects with relevance. Sarah Boone's lawyer tells the judge they are here about Miranda, but the judge says, how is it relevant? None of the case law provided by the defense is about that final line. Sarah Boone's lawyer says they are arguing that Sarah didn't waive her rights, but the judge says that is a different issue than what is on the card. The argument the defense is making is that the final line wasn't read to coerce Sarah Boone into making a statement. Sarah's lawyer says that Sarah was relying on the statement of routine protocol. The totality of the circumstances need to be considered. You're going to hear that a lot too. Totality. He loves that word. State says it's irrelevant. Just like the motive, just like motive is what makes it objectively what happens. I'm not sure what I meant by that. State says it is irrelevant, just like the motive. It is what. Oh. The state says it's irrelevant. The motive for what they said. It's all about what actually happened. That's what there's a lot of like. How do I want to put this? To me, there was a lot of twisting of what was the motive, why did they do this from the defense, and the state kept saying, it doesn't matter. It doesn't matter why they said or did whatever. What matters is what happened was allowed. That's, to me, that was really the crux of the issue. State also said we would call people by their surnames, not their first names. So yeah, that caused Sarah Boone's lawyer to turn around real quick. Sarah Boone's lawyer keeps saying we need totality. He loves that word, and the objection was overruled. Sarah Boone's lawyer then turns to the prosecution and asks what was wrong. What about a surname? It was that he keeps calling her Sarah, not Sarah Boone or Miss Boone. And the state interjected, you're not supposed to do that. Detective had a chance to review the Miranda card. The detective says she didn't read number 9, which is the final part of the card, according to the defense, because her card doesn't have number 9 on it. So the detective's card, her Miranda card, does not include this all-important number 9, do you still wish to speak to us part. It's not on her card because it's not needed, as the prosecution keeps claiming that it's not even on her card because at some point it wasn't on the card for the police, and some of the cards the police have don't have it on it. It's in the policy, but it's not on all the cards used by the sheriff's office. She's asked if she ever got an updated card, like basically, did you ever get a new card that had it after this case? Objection, irrelevant, sustained, but she did shake her head no from what I saw. So, I mean, we don't get a verbal, but she seemed to be ready to just say no, she's still using the same card. Which, I mean, if that card's fine, it doesn't matter, right? There was a moment of Sarah Boone's lawyer not saying anything here. I thought I would mention it because it seemed like he was kind of shifting for more information because, the objection just got sustained. Maybe he didn't know what to do now. Maybe he had to like shift through a lot that he was planning to ask. If this got stopped, more is going to get stopped. The detective said she did not tell Sarah Boone that she would be returning to Sarah Boone's apartment to give her phone back. This is a direct difference between what Sarah Boone has been claiming. The detective said she listened back to all the audio and they had plans to meet at the sheriff's office. She said she just told Sarah Boone she was taking the phone. She doesn't specifically remember a conversation about when she would return the phone. The detective has asked, do you remember Sarah Boone calling you about her cell phone from Brian Boone's phone? The detective says no. The detective is saying no. She doesn't recall a phone call from Sarah Boone, and then asks Sarah Boone's lawyer, is there documentation of this call? Sarah Boone's lawyer at this time says just Sarah Boone's testimony of the call existing. So to me, is Sarah Boone lying? We're going to have something more about this conversation about the possible phone and things that were said before getting in the car. There's a possible explanation the state's cooking up. You're going to like it. Detective says she does not recall the phone conversation. Detective says she told Sarah she would want to talk to her after the autopsy results came in. The videos were viewed on scene after the Sarah Boone interview. But she didn't talk to Sarah Boone again that day. So the order of events got reiterated again. This happens a lot. It gets reiterated. They met with Sarah Boone, talked in the car, videos reviewed after the car. She didn't speak to her again that day. Incoming a lot of objections and sustained, some not. Basically, at this point, we don't even get like the full question because it's just objected to, right? Like it's something you kind of had to see. It's just objection, sustained, objection, sustained. Some didn't get sustained, and we will talk about those. The detective made the decision that she had probable cause to arrest Sarah Boone at some point. Now, of course, all these responses from the detective are coming from something that wasn't sustained. When there was objection, she's being questioned, so this is her answers. I just didn't want to say, question and then the answer when it's the answer is the answer includes the question. You know what I mean? The detective got a search warrant for the phone and worked on the case that entire day until Sarah Boone came in. Detective says the autopsy was in the morning. That is why she asked Sarah Boone to come in later that day. Sarah Boone's lawyer asked when exactly Sarah Boone became a suspect. Objection for relevance, and the judge says he doesn't understand the relevance. Sarah Boone's lawyer says they already made a decision, but the judge asked, what does that have to do with the 3 motions? There's 3 motions today. The judge says the state isn't saying Sarah wasn't in a custodial interrogation at the police station. Miranda was read, just like before. So, the judge makes it very clear that the state isn't arguing if it was a custodial interrogation. Sarah's lawyer says, well, they also read Miranda when it wasn't a custodial interrogation in the car. Which, again, what does it matter? What does it matter that they read Miranda? Like, in another instance, when you're talking about... a lot of this just doesn't make sense to me. Like, they're trying to make an argument. You will get to what they're trying to do by the end. But he's trying to make some argument about her being Mirandized in the interrogation room. But it also involved being custodial. But also they Mirandized her when it wasn't custodial in the car. And even if they did, that's not like a negative. So like the objection was sustained. The judge also just seems to not know what's going on here. Detective agrees that when Sarah Boone arrived for the interrogation the next day that she would not be free to leave. So they knew when she showed up, she's not leaving, right? If Sarah Boone had invoked her right to remain silent, she would have been arrested anyway. They already had enough. Sarah Boone's lawyer tries to verify what that was based on. So he wants to know what basis were they going to arrest her. Objected, sustained. The detective had follow-up questions about the injuries. And she said that that Sarah Boone failed to mention and different things from the night before during that interrogation in the car, that discussion. The detective wanted to show Sarah Boone the videos now. She wanted to question about Sarah Boone's statement. In the squad car, that statement was inconsistent with the videos. Sarah's lawyer asked if the detective had read his motion with the start of the interrogation typed out, and the detective said no. Sarah's lawyer started reading it, and then there was an objection because the best evidence is a recording, and the detective had said she listened to the recording, so the judge sustained it. Sarah's lawyer asked, "Is it the policy of the police department to not ask a suspect any questions prior to Miranda?" The detective says you would have to direct them to the policy, but they weren't asking her any incriminating questions during that time prior to Miranda. She was explaining the purpose of the interrogation, and that will be in the interview. See, that's going to be kind of important what happened beforehand in like order of events. So you'll understand a little more when we get near the end about how all of this will line up, but I'm just putting it here because it's important later. Or at least they think it's important. She's asked about what they talked about before Miranda. It was briefly about getting autopsy results and wanting to speak with her. She's asked if she recalls reading Miranda right to her on the video, and asked if she recalls not reading number 9. She says she does. So she read Miranda and didn't include number 9, which wasn't on her card, and it's in the policy of the police department. But the state's arguing, of course, as we know, that it's not actually required. She had the card on her; it wasn't provided, so the detective had her own card, and that's what she read, which does not include number 9. Sarah's lawyer goes up to the prosecution and hands him something, and then goes to what I assume is the clerk of the court, hands him something, and it's waivers and affidavits, I think. The audio is really poor. The detective says it is filled out by her, but there is something highlighted she did not do. Detective verifies signatures. This is the consent to search. Miranda is on the paper, but she did not read from that paper aloud when she had it signed. The state objects again. Relevance. They aren't disputing she was in custody. There is no Florida case law requiring question 9. There is no federal case law requiring question 9. The judge asks for a response. The defense lawyer says, "We disagree." The judge says, "Then where is the case that supports that?" The judge goes through how he previously went over in court. He couldn't find case law in federal or state case law. This happened last time in court, where the judge made it very clear, I want case law, which is why we got this attempt here, which in the opinion of the state, in my opinion, was very poor. It didn't actually do what the judge asked. The judge was very big on give me case law, and Sarah's lawyer just still isn't supplying case law. I don't know why. I don't know why. I do know why. I assume why. I assume why is that case law for this doesn't exist. That they don't have a good argument using case law. Sarah's lawyer says she has a duty to read the rights. The judge says they were. Sarah Boone was read her rights. We all know this. It's verified. Sarah's lawyer gets to continue. The detective has an obligation to ask if Sarah understands her rights and a waiver of her rights, which would be question 9. Do you agree to speak to me now? This is the policy of the police department. The defense says he knows they only need to read those 4, but it is totality. He loves the word totality. You got to think about it in totality. Sarah Boone is going to testify now. State says it is the defendant basically saying they want to create new case law. So the state is just saying basically, look, they're wanting to make new case law. Because there isn't case law to support it. That's kind of the implication, because the defense isn't supplying the case law to support it, and they just keep saying totality, totality. The objection sustained, and the judge cites case law. The feed I was watching cut out at this point. Didn't seem we missed much. There were some issues with audio. I got through it. The detective said the interview in the interrogation room was different than the interview in the squad car because now there's more information. The defense asked if she was free to leave in the squad car. Detective says she didn't tell her that, but she didn't want to. She didn't want to talk. She didn't have to. This was all the questions for the detective from the defense. State has no witnesses, and now we bring in Sarah Boone. Almost Sarah Boone. Because first the defense introduces Defense Exhibit B. I think it was a form. State says objection. The defense says the same argument. Objection sustained. Another exhibit is the police department's policies, listing of the pages to read. The defense says same arguments. Objection overruled for this one. And now we get Sarah Boone. Now Sarah Boone is going to speak to us. And it's going to go as you expect. Sarah Boone is speaking in a very, very soft voice. It's not the voice you're used to, in my opinion, if you've listened to Sarah Boone on the recordings. Practicing for a jury, perhaps. Sarah Boone says that that day she was confused. She didn't understand the monumental amount of people that were at her apartment. She was worried about her dogs and her son. I don't remember that. I do remember her talking about cigarettes. Sarah Boone says she was traumatized. She was hungover and might still have been intoxicated. Remember that. Sarah Boone this is brought up with Sarah Boone's lawyer talking to her. Objection. Because her mental state wasn't brought up in any motions. Objection sustained. It's stricken. But you get to hear it here, so we get to mention that, that did happen. Sarah says she was asked to stay on the scene. Sarah Boone says she was asked when they arrived, did the detective take over the investigations? Objection by the state sustained. Like, why are you asking Sarah Boone if the detectives took over the investigation? That makes no sense. Were the detectives telling her what to do and where to go? She said yes. Sarah says one of the first questions asked was, do you own a phone by the detective? And Sarah Boone said it was on the kitchen counter. Sarah started to answer, I believe, to a question. And the state objects and it was sustained. You can't just go, I believe, I believe, I believe. So that got sustained. New question. Sarah was says she was told to unlock her phone by the detectives. It was handed to Sarah and she unlocked it. Unlocked it with a passcode. After unlocked, it was given back to the detective, and Sarah says she didn't see it again. Next time she was spoken to was for the unmarked police vehicle interrogation. She was told she was going to be asked questions. She asked if there was any mention of... Sarah Boone was asked if there was any mention of normal protocol before getting in the car, and Sarah says not that she could recall. And after in the car, she doesn't recall. So there was this whole argument about protocol earlier and how it was said because the detective said it, and then Sarah Boone's now saying she doesn't remember mention of it. That caught me as odd, but no one really seemed to follow up on that Sarah Boone said there wasn't any mention of it. I don't know. Maybe I'm crazy. That seemed to completely contradict what the defense was going for this whole time. And Sarah Boone is in the room, so she would know that her defense attorney's saying this. Sarah said she was read her Miranda rights. And Sarah said she answered the questions. They did not indicate she was a suspect. They did not indicate she was a person of interest. They never mentioned the videos on her phone, and they never questioned about anything on the scene after the interview. Yeah, so they never questioned about the videos at all on the scene. So that all got verified by Sarah, that the videos were not mentioned, were not questioned about. After the interview, she was allowed to get out, and Sarah says she was instructed to stay on the scene. That's different than the detective who said she was free to go. She said she was there for 10 hours or more. They all left at some point and told her they were done with the work at the scene. Sarah went into her apartment and then went to Brian Boone's home about 5 minutes away, and she drove to get there. She wanted to stay at her ex-husband's house because she was terrified of the victim's family. Now, maybe Sarah Boone didn't have any choice of anywhere else to go, but if you are accused, if you think that your boyfriend's family is a danger to you because they believe you murdered him, two things. Number one, I would not be going 5 minutes away. I would be going a farther distance, especially because I would assume Brian Boone, they could maybe find that address. Number two, I would not be going to the address that has my son if I am worried that people are possibly going to kill me. Doesn't get brought up. I just had to mention it. I was just like, why'd you do that? Sarah said she spent the night there. Sarah says she attempted to contact the detective using Brian Boone's phone. Sarah signed a form to let them take the phone. Sarah says she was told a detective would return to her apartment to return her phone. So Sarah's saying the detective told her they would bring her phone back. There was no talk of going to the sheriff's department the day before. Sarah knew the detective number because it was given to her, and she said she called it using Brian Boone's phone that night. She was told to call if she remembered something or wanted to talk about something about the case to call her. There was an objection sustained at this point. Sarah was concerned about the case and that she spoke with the detective. Sarah started to say she felt the detective was trying to trick her. Tricking is brought into the previous documents and things. Objection sustained when she said, I think she was trying to trick me. That got sustained. Sarah Boone was asked, did they have a discussion about the phone? Yes. Can she elaborate? She said she was asked to come down to the department because the detective was pregnant. No mention of being interrogated. The sole reason for the change in plans is because the detective was pregnant and requested it, according to Sarah Boone. Sarah drove to the sheriff's department next day, left her car, went through the front door, went to the window. And remember, a lot of this is not matching the detective story, right? I'm reading you what Sarah Boone is saying. Sarah said she was told to come upstairs, pick up her phone. She said she went up in an elevator with a detective who was wearing a red shirt and had his firearm on his waist. The firearm, the gun, is something that's being brought up by Sarah's lawyer as possibly coercive. But if it's a law enforcement person, why wouldn't they have a gun? Sarah had a list to ask them questions. She was brought into the interrogation room, and there wasn't any discussion before the interrogation room. Sarah watched the video of the interrogation. Sarah confirms the statements said during the interrogation before Miranda. So all the stuff said before Miranda: objection, relevance, sustained. So basically, Sarah, they're talking about things that were said before the Mirandas were read, but it was objected to because what does it matter? What does it matter? Because it wasn't like questions about the case. We continue on. Sarah was trying to follow the officer's demands. Sarah said that she said normal protocol because this is what the detective said the day before. Unless I misheard Sarah earlier, she said the detective didn't say that. So it's just weird to me. Maybe I misheard. I'm pretty sure I didn't. Let me know in the comments if I misheard that Sarah said that normal protocol wasn't said before and is now saying it was. Sarah was read Miranda rights without question number 9. Sarah said she was never asked, do you agree to speak to us now? Sarah Boone's lawyer asked if she felt if she didn't answer the question, she wouldn't get her phone back. State says objection. She was in custody. And this is the moment where I said Sarah Boone's lawyer seemed to not understand what's going on, seemed confused. Sarah Boone's lawyer turns back, confused, and says she was in custody? This has happened multiple times in this case, where very, very basic facts that have been repeated by the judge and the state just seems to go over her her lawyer's head. I don't know why. It's happened multiple times. The judge says this has been conceded by the state. We've talked about this, right? We know this. Sarah Boone's lawyer said Sarah didn't know that. The judge asked, what does it matter, her subjective perception of the matter? So basically, what does her opinion matter? Her feelings matter? What does it matter? She was in custody, whether she knew it or not, whether she understood it or not. Her lawyer said it matters under the situation. A detective was wearing a firearm in an enclosed space, being asked questions by the detective. I think her position is that she was coerced. And her lawyer saying, I think her position is that she was coerced. Maybe it's the wording for me, but it really just, to me, again, makes me think that this is being done to make Sarah Boone happy, not because he thinks it'll actually help Sarah Boone. The judge again asks, how is this relevant? The judge says the defense is making arguments that are relevant if this was a custodial interrogation argument, whether it was custodial or not. It is custodial. We know it is. This isn't an argument about coercion. The judge asks, what does her subjectivity matter under case law? As much as Sarah Boone's lawyer loves to say totality, case law gets said just as much by the judge. But I think the judge is more in the right to say it. The defense says they think it does matter, and the objection was sustained. And it was sustained, so none of that actually matters, right? But it really just goes to show what we're working with here. The defense asked if they ever said Sarah couldn't get her phone back until after she answers the questions. Objection. Sustained. Sarah Boone, again, they repeat that Sarah Boone had questions for the detective. Sarah Boone's lawyer asked, did you feel you had a choice in answering her questions? Objection. Sustained. Sarah came to the police department to get her phone. She didn't know that she would be arrested. She didn't know she would be questioned. She was trying to cooperate because the detective confirmed it was normal protocol. Now, state cross-examination. So Sarah is getting cross-examined. Sarah is asked if she was under the influence of alcohol when the police arrived. Yes. Sarah was asked, was she impaired? Sarah says she doesn't know if it went as far as impaired, and that consumption was from the night before. So, does that affect your memory when it comes to events between you and the detective that afternoon? So, Sarah Boone admits she was intoxicated in some level. Did that affect her memory when it comes to what her and the detective said? Because Sarah Boone is making a lot of claims of things the detective said, and that's what happened, but maybe she doesn't remember. Because, if you recall, Sarah Boone was blacked out the night before, at least according to her. Sarah asked for the question to be repeated. Sarah then asked, now or then? Then asked the question to herself out loud. The state repeats again the question and why it's relevant. Basically, I think they were preemptively fighting. They knew an objection was going to come from her lawyer, and there's preemptively, here's why it matters, so her lawyer wouldn't raise the objection. Sarah asked the question to herself again. Sarah then says, my answer, and then says nothing. Nothing. Then Sarah Boone's lawyer interjects saying, Sarah doesn't understand the question, and Sarah says, I don't. You don't understand if whether you being drunk could have impaired your memory? That seems like a very simple question. The state tried to repeat, and Sarah's lawyer at this point objected. The judge said he has to give legal grounds for the objection, so it can't be vibes-based, man. Sarah's lawyer has to give grounds for the objection. He can't just object because he doesn't like the question. Sarah's lawyer tried to argue, and Sarah Boone knows. But the judge again asked for legal grounds. What is the legal grounds to the objection? And then the judge just tells the state to proceed. Like, it's not working, right? Sarah Boone understands the charge she is facing, a possibility of life in prison. She's asked if she understands the minimum is roughly 22.5 years, and she said she didn't know. I don't believe it. I don't believe that Sarah Boone doesn't know the minimum. I don't believe it because she has to have had discussions when it came to possible plea deals. Why do we know that? Because her current lawyer has said he was trying to, before he became her lawyer, was working on getting a plea deal for her. So she had to have had this talk, in my opinion. The prosecution asked if Sarah Boone doesn't want the jury to see this questioning. Defense objects. Sustained. So the state is saying, would you not want the jury to see this line of these questions? And the defense objects. At least that's my understanding of what happened here. The state then asked if Sarah was planning to testify differently than in previous testimony. There's an objection by Sarah's lawyer saying he doesn't understand the question. The state claims Sarah is biased in all of testimony today because it is the state's belief that Sarah plans to testify at the trial differently than she testified in the interrogations. She wants those interrogations thrown out so she can testify like she did today without impeachment. Defense says the state can't use the things she said to the state expert she met with at the jail today if they want to use it during trial. So basically the defense is like, look, if you're going to try to use things she said to the expert today against her, you can't use it at the trial. And the state says they aren't asking Sarah specifics, but they believe it's a fair question to ask. Is Sarah Boone going to testify differently than in State's Exhibit 1 and testify this afternoon if she understands throwing these statements out would benefit her? The judge sustained the original question, but it can be revisited on the new explanation because the judge is going to allow it with the new wording. So, Sarah Boone is asked if her statements to the expert today were different than the previous interrogation, and she says yes. And Sarah Boone understands she was able to be cross-examined for inconsistent statements at trial. Sarah Boone says yes, and she understands the benefit of this motion to suppress and says yes. No other questions. The state is basically saying she's biased. She's doing this to get things thrown out so she can help her case. That's what this is for. Maybe she was drunk and didn't remember part of what she said. Sarah's lawyer time. Sarah's lawyer said it is his understanding of the law regarding Miranda, if it is a custodial interrogation, and it was, The court has to decide if it was given freely and voluntarily under the circumstances. After Miranda, law enforcement is trying to get a conviction, and the law allows law enforcement to lie. So what they're saying is that before Miranda, the police can't lie. After they can lie, that's what the law says. That's what he's going off of. Prior to Miranda, you can't trick. That right is fundamental. You can't be compelled to incriminate yourself. You can't seduce or coerce. We must punish law enforcement for that type of behavior. The minute before Miranda, the detective is saying we have to talk to you. It is confusing. It is deceptive. It is illegal. Saying that before Miranda is an illegal statement, according to Sarah Boone's lawyer. The judge interjects. The statement of we have to read you your rights came before the statement of we have to talk to you. So, according to the judge, Sarah's defense's argument is flipping the statements. They explained they have to read rights before they said we have to talk to you. Therefore, we have to talk to you involves reading your rights. That's my understanding of what the judge is basically saying, that you're flipping things. It has a different meaning. Her lawyer says that's why they even have the confusion. I mean, Sarah Boone was brought in under false pretenses after a traumatic defense, a traumatic event. So he's saying, like, her being brought in under false pretenses is a problem too. The argument is that isn't a valid waiver of her rights. And there was also no ninth question. He loves the ninth question. Sarah's lawyer says the critical question is, do you still wish to talk to us? Not according to the law, Sarah Boone's lawyer. Not according to the law. Not according to the case law cited by the judge and the prosecution. No, it is not the critical question. The detective had all the evidence and knew it didn't match the last interview. They wanted a confession. Under the totality, it is coercive. So the argument is, the defense's argument, the detectives lied to get Sarah Boone to the station. They knew going in they were going to arrest her, and they were coercing her, and they also didn't say the final line of that Miranda card that wasn't on the card, but it was in the policy, and therefore, the totality, it was a coerced interview, coerced statement. Sorry about that. State says they stand by the case law they have cited. Sarah knowingly and voluntarily waived her right correctly under case law. And they are allowed to use deception to get someone to come to the station. By her own admission, due to the consumption of alcohol, her credibility is less than the detective. Sarah has a bias, and the detective doesn't have a bias when it comes to lying about how they got her to come to the station, because she's allowed to lie. State's done, defense is done. Tomorrow is a court holiday, but the response will be by the end of the day. Now we have more motions. They're less important, but we have more motions. The motion about clothes and leg restraints. The state says this has already been decided. The defense says that leg restraints bias the jury. There is more, but that's the basis. The state mentioned that this isn't case law. The judge says you can provide clothes to her at the Orange County Jail. Approval for clothes makeup isn't addressed in defense motions. It is contraband in the jail. The defense wants his own team members to apply makeup to Sarah. State says he has no dog in this fight, but just never heard of it happening. The judge says he will deny makeup at the jail or secured area, but his people will allow Sarah to apply makeup at court with, like, basically they're saying that her lawyer's people can apply makeup to Sarah at court. Leg restraints removal will have a written order, and hair as well. And hair will have to be done in the courtroom as well. But then corrections interrupts. Corrections gets in and says, hold up. What about removing the makeup? Because if it's not removed, then it's contraband getting back into the jail, and now it sounds like it can't even be done. So the whole makeup thing might have just been moot now, because it's contraband. She can't come back into the jail wearing makeup. So now is a protective order motion. The defense says he didn't know it would be today. The judge says it was emailed to them. Again, her lawyer just seems confused. This is one where all the state employees and the state is trying to block it due to work product. The defense says they're trying to introduce George Torres' past arrests and the drop ones after Sarah Boone asked, which is common for battered spouse. So the defense is saying, we want them there to talk about his George Torres' past arrests and how they got dropped, partly because of Sarah Boone, because this happens all the time in battered spouse. But the state makes a decision to drop the cases, not Sarah Boone. So my assumption at this point is that basically they want to use the fact, how do I want to put this? They want to use the fact that it's common for for Sarah Boone to ask for the case to be dropped in the case of a battered spouse, but those droppings don't mean that they weren't valid. It's actually the state's decision, so therefore they basically setting it up so the jury won't hold it against Sarah that she asked to have it dropped. The judge asks, how is this not work product? The defense says it's the state's decision to drop the cases, not the victim. State says work product is absolutely protected. Arrests and dismissals aren't relevant. It is what the victim knows about the violence the perpetrator has done and their reputation. People not even involved in this case are being subpoenaed, and the state is attempting to squash them right now. They need to compel discovery from the State Department if they want information. The state just got Sarah Boone's health records from 2021 that her defense has had for years. So now the state is claiming that Sarah Boone's people have been holding back evidence. Now the state has to combat these subpoenas. The ultimate protection is why we drop those cases. Sarah can say she asked to have charges dropped. Her phone evidence shows it being discussed, and even has Sarah coaching the victim to drop charges against her on her phone. So the state's saying Sarah Boone can talk about how she asked to have them dropped. They can talk about how the state makes the final decision. They're also kind of putting out there Sarah Boone had charges against her, and she was coaching the victim, George Torres, to drop those charges against her. So the state's basically like, we'll throw it right back at you. Kind of at the end there. Defense says that wasn't his argument. He just wants them to explain that they have the power to do it, not why they did it. The state controls the case, not the victim. There'll be a written order tomorrow. My assumption with the written orders is I think that the motion to suppress is done. I don't think that's going to work. I think it went really bad for Sarah Boone. I also suspect that he's not going to force these people to testify. The judge is probably just going to say, obviously, you can tell the jury that the state makes that decision. They don't have to physically bring these people in to then say it's the state's decision and then take them right off the stand, because you can't ask them anything else. Yeah. So that was long. That was long. Not as long as the actual trial, but that was long. That was my notes. That was what I have to say. Could be big. Could be big. We'll have to see. That's all there is to say about it. Sounds like makeup's dead. Sounds like Sarah Boone's really bad on the stand. Sounds like her lawyer's really not. He's not sounding too hot in the court. If it comes down to case law, things aren't going too great. And it seems to be coming down to case law. So I would not have much hope if I was Sarah Boone tonight. I'll put it that way.